NACDL is the association of the nation's criminal defense bar.
Good afternoon, everyone, and welcome to today's webinar. My name is Monica Reed. I have the pleasure of serving as the Director of Advocacy here at NACDL. Again, we want to thank you for joining today's webinar discussion, which is going to be looking at an overview of voter prosecutions in this country. And to get us started, I actually want to introduce one of our board members, Florida-based criminal defense attorney, Ray Delicabata. He's a member of our board of directors and co-chairs our Criminalization of Voting Rights Committee. I want to kick it over to him to give brief words of welcome to everyone.
Good afternoon, everybody. Thank you for the introduction, Monica. I'm actually traveling to meet a client, so I pulled over on the side of the road. We are very proud of the work that we're doing in this committee. I've had the pleasure of working with Blair and others and other organizations to address what we perceive to be a crisis issue in this country, the criminalization of someone's right to vote. It is, since we started this committee, what we've realized that it's not just about returning citizens, it's about stymieing organizations that are out there trying to register voters, trying to do anything in their power to limit access to the ballot box, even to the extent of criminalizing acts around your ability to vote. So what we've done as an organization is reached out whoever needs a helping hand, or League of Women Voters. We've spoken at NAACP. We've spoken at a bunch of different organizations so people know their rights. Not just returning citizens. We fielded calls from them that are scared that they may be next and getting arrested. But we've also spoken to, excuse me. We've also spoken to organizations that are out there with canvassers trying to register voters, and how they're getting intimidated by law enforcement. People showing up without warrants, without subpoenas, just snooping around, trying to make their presence felt to intimidate people from doing the work that they're doing. It is what fuels me to do this work on behalf of the organization is that I hate this bullying tactic. I hate that people are trying to exercise their constitutional right to vote, and that's getting stymied or hindered. So, these events are crucial in getting everyone excited and enthusiastic about doing something about this, because this affects us all, not just these poor people that can't get to the ballot box, but it affects policy, it affects everything. So I personally take great pride in working with my colleagues. Seth Chasen is the co-chair of the committee. He's been a fighter in this issue for many, many years. So please consider NACDL a resource in this battle. And anything that I can do, I'm just an email away. Thank you, Monica.
Thank you so much, Ray. Thank you for your dedication and get to your destination so safely. As Ray has mentioned and sort of highlighted in the work that the committee is doing, and what today's webinar is seeking to do, is really sort of draw attention to this issue. We do have two great speakers today. One being Mitchell Brown, Senior Counsel, Voting Rights Section at the Southern Coalition for Social Justice, and Blair Bowie, Director of the Restore Your Vote Project at the Campaign Legal Center, who have been two great partners in this work, and you are going to hear from them today. With that, I want to turn it over to our first speaker, who's going to be Mitchell Brown, and then immediately after, you'll hear from Blair Bowie.
Thank you, Monica, for the introduction. Again, my name is Mitchell Brown. I'm Senior Counsel for Voting Rights at the Southern Coalition for Social Justice in Durham, North Carolina, but I'm physically in Washington, D.C. Thank the pandemic for that. I moved up here to D.C. with my wife. So it's great to be here today. And I want to start off my remarks with this comment that I started in this work around the criminalization of the ballot box, or the criminalization of voting, in 2019 when I was an Equal Justice Works Fellow, and I was responsible for creating a criminalization of the ballot box convening and leading that effort in 2019. And one of the things that has always stuck with me is during that convening, we heard the story of Crystal Mason, and how when she was first indicted for voting while she was ineligible due to her felony conviction, she went and talked to a bunch of different attorneys, a bunch of different organizations that specialized in voting rights, and nobody had any experience with this work. Nobody, she couldn't find anybody that could help her. And that's always stuck with me, because that fuels me to do this work, and fuels me to make sure that there are resources and there are people out there that can assist voters who may find themselves in the crosshairs of a prosecution simply for the act of voting, or the act of assisting, or anything that is voting related that the state would try to use to intimidate them. And so I just wanted that just gives you some context to where I'm coming from with this. And I think it's very, very important that we're doing this work. And so I'm grateful to be here today. So just to give a little bit of overview, you may hear the term criminalization of voting or criminalization of the ballot box. And what I mean by that is the abuse of public and private power to intimidate minority community members from voting for fear of criminal prosecution. And there are a couple of different instances that I'll talk about in a moment that deal with the criminalization of the ballot box, whether it's actually the right to vote because a person is ineligible due to their felony conviction, or whether it's they are non-citizen and they voted, or they're trying to assist voters and they are prosecuted for illegal assistance or improper assistance. Those are a couple of types of ways that states are trying to criminalize the act of voting or criminalize access to the ballot box. And so this is something that we have to continue to fight back against, because it has a chilling effect on voters. Ray in his opening remarks really touched on that, and I think, and I'll add a +1 to that there is a chilling effect on voters, and there's a chilling effect on the organizations that are seeking to register voters. We, SCSJ, filed a lawsuit against North Carolina's voter prosecution law in 2020, and it's still ongoing. We're at the summary judgment phase of the case, and one of the biggest reasons why we brought that case is because of the chilling effect on voter registration organizations that do voter registration, because they are going out to communities and people are scared to register to vote because they've heard that people are being prosecuted. They may have a felony record, they may be a non-citizen, and they may just be confused about their ability to vote. And so they don't want to register to vote. And that really hampers and hinders the mission of the organizations that are seeking to register them to vote. And so that's why we brought that case. And I'll talk a little bit about that in a minute. So I just want to go over some of the history and give you all some context to why this matters. This matters because in this country, there's been a legacy of suppression of Black voters in particular, starting with the outright denial of personhood, to disenfranchisement by violence, to laws such as felon disenfranchisement laws that disparately impact Black voters. And this violence and this use of the law to impact Black voters really started after Reconstruction, after slavery ended and federal troops left the South. There was what some historians would call a retrenchment period, where Black voters now had the right to vote, and the white electorate and white population decided that, hey, Black voters don't deserve the right to vote, so we're going to do whatever we can, to stop them from voting, whether it be extra legal such as violence, or using laws such as grandfather clauses, poll taxes, voter prosecution laws, or felon disenfranchisement laws to stop Black voters from being able to access the ballot box. And so in respect to the ways voters are being prosecuted, they're being prosecuted for voting. And what I mean by that, I don't mean to make it so simple, but in the state of North Carolina, for example, if you vote while you're ineligible, then you are automatically guilty of another felony, because you have not completed your sentence. If you voted while you're still serving a felony sentence. And in North Carolina, it was strict liability until this year, when the state legislature passed an amendment to that statute, which added a mens rea requirement to the law. But before then, if you voted and you were ineligible due to a felony conviction, then you were automatically guilty of another felony. And all the state had to prove was that you voted. And so if you voted because you were confused, if you voted because a poll worker said, "Hey, I don't see you on the rolls, but you can vote," then you're guilty of voting while you're ineligible, and that's another felony conviction, and the process starts all over again. And so, these felony disenfranchisement laws across the country are very, very confusing. The example I use North Carolina as an example. Florida is another example. In Florida, you had the fight to repeal the Florida felony disenfranchisement statute that went through the legal process and is now still in effect in Florida, still disenfranchising people with felony records, and now they're prosecuting voters because they're voting due to their inability due to them still being serving a felony conviction. But the issue is that Florida can't tell them what fines and fees they may owe. And there's an article that I'm going to put in the chat here that really, details why it's important. This reason that the Florida can't say what people owe in fines and fees. That's very, very important, because if you are going to disenfranchise somebody because they owe fines and fees, and you can't tell them how much they owe, then you're basically excluding them from the voting process. And so that article I just linked in the chat really explains what the issue is around Florida not knowing what fines and fees people owe. It's a relatively old article, but I believe the information is still relevant to Florida. And then going back to North Carolina, and a more personal example for myself, I in SCSJ in 2018, before I got to SCSJ, represented a couple of voters in Alamance County, North Carolina. And one of our clients, she got caught up in the voter prosecution audit of 2017 in North Carolina. And in 2020, towards the end of 2020, she received a letter from the state saying that she owed $1,000 based on probation fees. And she didn't know anything about this. She thought she had completed her sentence, well before then. And so issues like that, where the state is able to just say, "Hey, you owe us money," out of the blue, really puts voters at risk of being prosecuted for voting while they're ineligible. So the voting while ineligible due to a felony conviction is one piece of it. Other pieces of it are voter assistance, and also seeking to register people to vote, and you're doing it incorrectly. So all of these add up to the criminalization of voting and the voting process. And there are a couple of substantive issues that I see with these voter prosecutions. One, many of these violations stem from a place of confusion. People don't know what their rights to vote are. They don't know when their sentence ends, and neither does the state. And so when these violations stem from a place of confusion, as you see in North Carolina and in Florida, people are caught in the crosshairs, and they're being, indicted and convicted of voting while they're ineligible. The second substantive issue is that voters are selectively prosecuted. In North Carolina, there was an audit in 2017 where the state of North Carolina found 441 people voted while they're ineligible. Of that 441, only 25 or so were actually, went down the road of prosecution. And 68% of those voters were Black. And so you're looking at the DAs in certain counties are saying, "Hey, it's my job to prosecute people, so I'm going to prosecute these laws." And then we have other evidence that DAs said that there's no intent behind this, so I'm not going to prosecute this person for a mistake. And so you have, depending on what DA is in your district, they're either prosecuting voters or they're not. And one very prominent example is there was a lady in North Carolina. I forgot what county it was, but she voted in her dead mother's name, like intentionally voted in her dead mother's name because it was her dead mother's dying wish to vote for Donald Trump. And her mother passed away before the 2016 election, and her daughter voted for herself in her name, but also voted in her mother's name. And the district attorney in that county decided not to prosecute her because it was an honest mistake. However, that same standard was not used for Black voters who were prosecuted in other counties for unintentionally violating the law by voting while they're ineligible. So this selective prosecution is a substantive issue. And then lastly, these prosecutions have the effect of limiting the electorate. There are instances where voters are refusing to vote because they're scared. Another one of our clients from the Alamance County case said that not only is he never going to vote again, but he's going to tell his children to never vote again. And so we have this generational disenfranchisement and generational fear that's being passed down throughout the community, especially those who have felony records, and it's limiting the electorate, and it's chilling the right to vote for many people, and that's an issue. These are a couple of prominent examples that I want to raise. The first is Crystal Mason out of Texas. She received 5 years in prison for voting while she was ineligible. Then you have Rosa Marie Ortega. She received 8 years for voting while she was ineligible due to her being a non-citizen. And she was actually paroled and then deported to Mexico, where she's originally from. However, she had immigrated to this country, over 30 years before her conviction, but she was deported because she was a non-citizen. And then you have Whitney Brown and Keith Sellers out of North Carolina, two of our former clients, who we were able to represent them and get them to plead to misdemeanor obstruction of justice. But again, that's another charge on their criminal record that they had simply because they mistakenly voted. And then you have Xavier Artis and others in Florida. Xavier is just one of the folks in Florida who was prosecuted, and he received 13 more months in jail for voting while he was ineligible. So these voter prosecutions have real consequences and really have a chilling effect on voters. And so, as I stated earlier, these laws are really tied to a post-Reconstruction America, post-Reconstruction South, where there was a effort of retrenchment and a resurgence of white supremacy in the South that really led to a lot of different laws being passed to try to disenfranchise and limit the Black electorate in the South. And so one of the tying factors amongst the South is something called the Mississippi Plan. So the Mississippi Plan came around 1890, and in that plan, the state of Mississippi was decided to pass poll taxes and grandfather clauses and literacy tests to try to diminish the right to vote for Black voters that were newly enfranchised. And then in many other states, they added, really relied on felon disenfranchisement laws and voter prosecution laws to further, limit the electorate and further disenfranchise Black voters. And that was very, very problematic. And the issue is that out of all of those laws that were passed in various southern states, so the poll tax, the grandfather clause, the literacy test, and voter prosecution statutes. Voter prosecution statutes are kind of the only one that really still exist in states because the other three have been outlawed, even though they were all passed with the same, discriminatory effect and intent behind the laws. And so when you have this package of laws that is meant to disenfranchise Black voters and only one still exists, it kind of begs the question of why does this law still exist? And that's one of the arguments that we made in our voter prosecution case in North Carolina, is that this law was passed with discriminatory intent and still has that effect on Black voters. And so this history is being carried forth into present day. It's connected to the Jim Crow era, but it's not stuck there. It still has the effect of these laws, particularly felony disenfranchisement laws and and voter prosecution laws really has an effect on Black voters. And that's not to mention the other efforts to suppress the right to vote via redistricting or voter ID laws or other types of voter assistant laws that really are trying to, again, limit the electorate. And so one last thing on this slide here is that felony disenfranchisement laws are legal under the 14th Amendment, under Section 2 of the 14th Amendment. Felony disenfranchisement laws are legal. However, in Alabama, the Hunter v. Underwood case in 1985 showed you can't disenfranchise people in a discriminatory manner. And so I would encourage folks to read that Hunter v. Underwood case because it really gives insight into how to attack felony disenfranchisement laws. And so these are two political cartoons that were drawn in the late 1800s that really show that there was an attempt to limit the Black electorate and to fight back against what people would call Negro rule. And so one quote that I want to share with you all comes from North Carolina when they passed the voter prosecution law in North Carolina, said that the purpose of the suffrage amendment, which included the voter prosecution law, literacy tests, poll taxes, and the grandfather clause, the purpose of the suffrage amendment was to save the state from Negro rule because the illiterate Negro was unfit to be on the ballot, unfit for the ballot. And again, the only remnant that's left of the suffrage amendment is the voter prosecution statute. And we filed a case and we're in summary judgment right now. And we hope the court agrees with our argument that this law is discriminatory and should be stricken from the law books. However, in bringing that case over the last 3.5 years, we put a lot of pressure on the state of North Carolina to pass or amend the law to add the intent requirement. And they finally did that this year in the midst of other bad voting laws. This is one positive thing that the state did. So our pressure really helped to create an intent requirement for the law. However, the law is not retroactive, meaning that if a person, voted in the 2022 election, the 2020 election, while they're ineligible, and we do have evidence that, there were some investigations into folks who voted while they're ineligible due to a felony conviction, those people can still be charged years down the line because North Carolina doesn't have a statute of limitations on felonies. And so that's one of our arguments that we made to the court, say, hey, even though this law was amended, the previous law still has an impact on voters and should be stricken. And so we'll see in the coming weeks what the court does with that. And so we talked a little bit about this, but just various iterations of voter prosecutions. The one I really want to focus on is in Georgia, here at the bottom, Olivia Pearson. So Olivia Pearson was also a former client of SCSJ during her first trial. And she was indicted for improperly assisting a voter in false swearing. And she was a poll worker. So she was a poll worker and was helping, a voter at the ballot box. And she was accused and charged with, improperly assisting a voter in false swearing in the state of Georgia, and was looking at multiple years in prison for doing her job. She was acquitted after the first trial ended in a mistrial, and the second she was acquitted. But it's the fact that she had to go through all of this legal process for simply doing her job as a poll worker. And that really took a toll on her and really shows that there's this I'll call it a phantom fight against the specter of voter fraud. And as you see in many different states, there are voter fraud task forces in Georgia, voter fraud task forces in Florida, voter file audits in North Carolina, all with the attempt to try to fight back against voter fraud that does not exist. When I use the word specter, I do mean specter. It is a phantom. It is a ghost. It does not exist or exist in the way that folks would have you think it does. And so these task forces are simply looking for a problem where one does not exist. And so Olivia Pearson got caught in that fight against voter fraud, and luckily she was acquitted after her second trial. And so that begs the question: are we regressing? Are we going back to a time where Black voters are going to be suppressed and not able to express their voices through the ballot box, or are they going to be prosecuted and again taken off the voting rolls? The picture on the left is from 1964, and then the picture on the right is from 2018. And Black voters are still fighting for the right to vote. And I mentioned voter fraud, and I mentioned that a lot of these voter prosecutions are centered around stopping voter fraud. That was the same type of argument that was made back in the late 1800s to pass the literacy test and the poll taxes and felon disenfranchisement laws. It was trying to stop voter fraud, or that's what they said. But voter fraud has now been used as a scapegoat to disenfranchise Black voters, and that's an issue. And so, are we regressing? We are regressing. Our voting rights for voters are being stricken from the law, and we seem to be going backwards. However, there are still attempts to maintain the status quo, which is Black voters and other voters of color should not have the right to vote. And there are certain people in our society that would do everything they can to stop voters of color from exercising their right to vote, including voter prosecutions, which desperately target voters of color. So we're regressing a little bit, but we're going back to the status quo. And so what kind of things can we do to support as I wrap up? So one of the things that we can do, and when I say we, I mean all of us, is educating people about these issues. So having these educational events, going to talk to your local communities about, hey, this is an issue in our community. We need to continue to fight back against it because many people just don't know about it. We did some messaging work in 2019, 2020. And this is after in North Carolina, and this is after the big voter prosecutions in 2018. And a lot of people said, I just didn't know about it. And so, education is important. And other things is just research on the prevalence of voter prosecutions and their chilling effect. And then just if there's the ability to give overall support to defending folks who are being prosecuted for voting, that's something else that we can do. And then lastly, what we can do is, we need to find data regarding the prevalence of voter prosecutions and data about the chilling effect. That's something that has been very hard to quantify. Like, what is the chilling effect of these laws on voters? And that's tied to the last point about we need the voter narratives. Like, we need people who have been prosecuted and aren't afraid to tell their story. We need them to tell their story and to share that with the media, share that with our communities, because their stories are very, very powerful in explaining the really personal effect of these voter prosecutions on them and the communities in which they live. And so that's something else that we can do. And here's my contact information, and I'll turn it over to Blair.
Thanks so much, Mitchell. So my name is Blair Bowie. I'm the director of the Restore Your Vote program at Campaign Legal Center. Like Mitchell, I got involved with this work during a fellowship where I was focused on helping folks with past felonies restore their voting rights, especially in states that have really complicated laws. And through that work, we started a website and a hotline that helps people in all 50 states figure out how they can restore their voting rights. And over time, I started getting contacted by folks who were being threatened with or actually prosecuted for unknowingly voting or registering when they were ineligible. And I have to say that the first person I reached out to about that was Mitchell, and he's such a great resource and expert on this topic. And since the prosecutions in Florida started, I've been working with Ray and Seth, and just watching them put together this national network of folks interested in this issue is really a huge step in the right direction. So I'm really grateful to everyone for being here today and being focused on this issue. So Mitchell talked about what's happening in Florida, and I also saw from the comments that a lot of folks here are from Florida, so you may be familiar with a lot of this, but I think it's really important to emphasize the story of what happened in Florida and what is still happening in Florida as an exemplar of the trend in these prosecutions across the country. And I should say I will be focusing on prosecutions of people with felony convictions for registering or voting or attempting to restore their voting rights, since that's my area of focus. And I want to make clear, and I think Mitchell did a really excellent job of tying these current prosecutions and the laws that they're being drawn from to the Jim Crow era. That's what these laws have always been for. It's what they're still used for. And the rise in these kinds of prosecutions does not represent a sudden spike in criminal attempts to steal the ballot box. Still, study after study shows that there's no evidence that illegal voting and registration is anything but rare. I think the other angle here is states that are bringing these prosecutions will talk a lot about protecting the integrity of the ballot box, which again is literally a talking point from the Jim Crow era. But if they were really concerned about the integrity of the ballot box, if they really wanted to prevent ineligible voters from casting ballots, states would focus on screening voter registrations and removing people who are ineligible to vote from the voter rolls before they cast ballots on election day, instead of spending all their resources going after people afterwards. And that's why the goal of these prosecutions is really clearly to intimidate and scare eligible voters away from the ballot box. So I think that Florida really illustrates this point. In 2018, as many of you know, Floridians overwhelmingly passed Amendment 4, which was a ballot initiative designed to restore voting rights to over an estimated 1.4 million people who had finished serving their sentences. This was the largest expansion of the franchise since the Voting Rights Act of 1965, so a major civil rights victory. But Florida's legislative majority opposed rights restoration and set out to undermine the amendment by passing legislation that added a requirement that people had to pay off their fines, fees, and restitution before they could vote. Now, you all are criminal defense attorneys, so I don't have to tell you how exorbitant these legal financial obligations can be or how confusing they can be. Many people who owe don't know that they owe, and as Mitchell pointed out, the state is unable to tell people what they owe or how to even obtain or read the records that show those debts. And in Florida in particular, the entire criminal legal system is supported by these debts, and few people are ever able to pay them back. So in essence, the Florida legislature created a modern day poll tax. Two people could be convicted of the exact same crime, receive the exact same sentence, but if one is rich and one is poor, the rich one is going to be able to buy their right to vote back, and the poor one will never vote again. That is a poll tax. So these new requirements shrunk the reenfranchising impact of Amendment 4 from 1.4 million people to only about a few 100,000. The legal financial obligation requirement was quickly challenged in the federal courts, and that led to both a preliminary injunction and a final injunction at the district court level. But then there was a stay on the injunction by the appellate court, and finally the 11th Circuit reviewed en banc the opinion and allowed the new law requiring payment of legal financial obligations to remain in place. That created a lot of confusion. Over the span of a year and a half, the law changed drastically at least 6 times. And when all was said and done, over 85,000 Floridians with past felonies landed on the voter rolls, but their eligibility to vote in the 2020 elections was in question. And it's important to note that at trial, what I've got up here is a transcript from trial. The director of Florida's elections testified under oath to the federal court that her office would verify the eligibility of all of those 85,000 voters, and that it would cross-check all registrants' eligibility for compliance with the new law every day. I think anyone who was paying attention at the time thought that they didn't possibly have the resources to actually do that, even if they had wanted to. So the attorneys who were challenging the law raised the concern that people would make good faith mistakes about their eligibility and that they could be prosecuted for those mistakes. The district court took those concerns seriously, but the 11th Circuit brushed it off. This is from their en banc opinion, where they insisted that honest Floridians would be protected from prosecution by the law's scienter requirements, and that the argument that Floridians would be prosecuted for good faith mistakes strained credulity. Yet here we are 3 years later, and dozens of Floridians have been prosecuted for mistakes about their eligibility, including people who registered to vote while the legal financial obligations were stayed, including people who were registered in jail by county officials, including people who were arrested in the early hours of the morning at gunpoint, hearkening back again to the Jim Crow era. And all of this without a whiff of evidence in the affidavits to establish probable cause that they actually knew they were ineligible when they registered or voted. So it's clear that Florida did not fulfill its promises and legal responsibility to confirm the eligibility of those 85,000 registrants before the 2020 elections. And what's worse is that it's pinning the blame on its citizens who genuinely and reasonably believe that their voting rights have been restored. But Florida is not alone. These messy laws and confusing registration processes exist all across the country. Nationwide, more than 25 million, about 24, 25 million Americans have been convicted of felonies, but fewer than 5 million are actually disenfranchised under law as a result. So that means that roughly 80% of Americans with felony convictions do have the right to vote. However, many are not aware of their eligibility because of persistent misinformation, complicated laws, insufficient instruction, and a lack of access to credible legal information explaining their rights. As a few people have pointed out in the chat, I saw Ann and Nicole in there, this kind of de facto disenfranchisement is exacerbated by these high-profile prosecutions of people who were mistaken about their eligibility. The message is clear, right? The states are saying, don't even try to exercise your right to vote because the consequences of a mistake are not going to be worth it. So in the face of this attack on voting rights, democracy really needs strong champions to defend people with felony convictions who acted in good faith but are being prosecuted nonetheless. So the bulk of my presentation is focused on some of the lessons that I've learned from helping out on these cases, from closely following others. All of these are just observations that might be helpful to building a strong defense. Again, we need more people working on these cases, and if you are working on these cases, there are a variety of resources available, including the NACDL working group, me, Mitchell. Please reach out. But let's get into it. All right, so this may seem obvious, but disenfranchisement and reenfranchisement laws are varied, confusing, fluctuated. They're very complicated. That's by design, of course. And these laws are set at the state level, and they're really a patchwork all across the country. And you have to think both when you're dealing with these cases about what the law is governing disenfranchisement and what the law is governing reenfranchisement. On the disenfranchisement side, 2 states, DC and Puerto Rico, just don't take away the right to vote for felony convictions at all. A handful of states only take away the right to vote for certain convictions. For example, Mississippi only takes away the right to vote for a list of about 20 state convictions that's in their state constitution. Other state felonies, federal convictions, out-of-state convictions do not take away the right to vote at all in Mississippi. In Alabama, there's a list of about 40 convictions that take away the right to vote. Those are listed in statute. And again, the others never disenfranchise. So even if somebody is serving prison time for a felony that's non-disqualifying, they maintain the right to vote. Most states disenfranchise for all felonies, and some states also disenfranchise for some or all misdemeanors when people are serving time in prison. On the restoration side, again, things are really varied. That's what this map focuses on. About half of the states automatically restore voting rights when somebody leaves prison. That means somebody can register to vote as soon as they walk out of the prison doors. The next largest group automatically restores voting rights when people finish supervision, probation, parole. And then all the rest can be quite complicated. Some require payment of fines, fees, and restitution, or some variants thereof. Some have a waiting period after sentence completion. Some require seeking a certificate of eligibility to restore voting rights. Some require you to go to court. And those rules can vary depending on the date of conviction, the number of convictions, and the type of conviction. So you can see how people can be confused about their eligibility. 2 states require executive clemency, but they have systems to automatically grant it for certain people. And then there are 3 states, Mississippi, Tennessee, and Virginia, that effectively permanently disenfranchise people who've been convicted of felonies and lost the right to vote because their rights restoration schemes are basically impossible to complete. For example, in Mississippi, to restore your voting rights, if you've been convicted of one of those crimes that does take away the right to vote, you have to get the state legislature to pass a bill that personally reenfranchises you by a 2/3 vote. And by the way, this gets even more complicated when you're talking about a person who lives in one state but had a felony conviction in another state. So the first thing a defense attorney needs to do is get really familiar with the law and figure out exactly what the circumstances were around their client's disenfranchisement and reenfranchisement, and know also that the law may have changed between when the alleged illegal event happened and when you're taking on the case. So because these laws are so complicated, significant ambiguity can be baked into the question of whether a defendant was eligible to vote or ineligible at all. And I want to point out that election officials frequently make mistakes about people's eligibility. A couple of major examples I've seen in Morgan County, Alabama, the registrars were consistently denying eligible people to vote. And that's because in 2017, Alabama passed the law that defines which felony convictions take away the right to vote and which don't. But the registrar there thought that the law only applied to people convicted of felonies going forward. And so for people who had had their felony convictions before 2017, they continued to use the old standard, which in their mind was disenfranchising everyone with a felony conviction. So they continued to turn down people and purge people from the rolls who were perfectly eligible for years after Alabama passed its new law. There can also be, again, sticking with Alabama because it has this list of crimes that do disenfranchise and every other crime does not. There's a lot of ambiguity around which out-of-state convictions take away the right to vote. And registrars have to make that determination again, and they're not trained at all. There's no standards that have been given by the Secretary of State. So they really often do it just based on the name of a conviction. And one place where I've seen this get very confusing is a lot of Alabamians who have assault convictions in Florida. In Florida, an assault is sort of the like classical common law assault where like you could yell at somebody and be convicted of assault. And then if you actually make physical contact with someone, it's battery in Florida. Alabama has totally different names for those crimes. In Alabama, the sort of like yelling at somebody assault is called menacing, and the battery assault is called assault. So assault in Alabama is disenfranchising, but that same conviction would be just considered menacing if you're convicted of assault in Florida. So a lot of people are being wrongly disenfranchised for doing something that is not actually disenfranchising in Alabama. That can be quite complicated for registrars. And again, elections officials are not equipped with the right skills to be able to tell whether something is disqualifying or not. So again, it's important to check the law at the time of the alleged act. These laws can change a lot. Sometimes policies change. These laws can be governed by things beyond legislation, like Attorney General's opinion. For example, in Tennessee, Tennessee used to recognize if somebody had an out-of-state conviction and they got their civil rights restored in that state, they would recognize that as sufficient to restore voting rights and let that person vote in Tennessee. And then they sort of quietly changed their position on that. That could lead to somebody registering illegally, theoretically. So again, check the law at the time, get familiar with the law, and know that elections officials are sometimes making mistakes. One thing I mentioned earlier is that people are being prosecuted not just for voting when ineligible, but for registering to vote when ineligible. So if you have a client who is accused of illegal registration or a false statement on election forms, it's so important to get the actual form and look at the language that they actually signed or attested to. Particularly when we're talking about voter registration forms often contain an oath to eligibility, and they will sometimes also include instructions or an explanation of the eligibility criteria. But some of these registration forms have really deficient instructions and vague attestations. So you want to look at that language because a person can't have committed perjury or a similar crime if they never made a false statement or if they didn't know that the statement was false. So examples here, some states just have these really vague attestations like, I affirm that I am not a convicted felon, this top one in the left corner that's from Florida, or if I am, my right to vote has been restored. But then you can see right next to it that the form doesn't explain what restores the right to vote in Florida. So this would be really confusing for someone trying to figure out if they're eligible to vote. Similarly, you have an attestation. This one is actually much better. Some states use sort of knowable facts in the attestation. So the one in the middle here is from Utah, which just requires somebody to attest that they are not currently incarcerated for a felony conviction. That is a fact that somebody is likely to know or not know, rather than just saying, which they could have said, I affirm that I've had my civil rights restored. This form explains that your civil rights are restored when you are released from incarceration in Utah. So again, important to look at these, both to see if your client actually attested to something that wasn't true, but also to see how the eligibility requirements are explained. These forms can also be wrong. If the law has changed, sometimes the forms haven't caught up. So just really important to get into the weeds of what they actually signed or attested to, or what was explained to them on these forms. At minimum, when you're looking at these forms, you can see, even if your client attested to something that was ultimately false, like I've had my civil rights restored, the way that that is explained really speaks to the question of whether they actually understood or knew that they were ineligible, which sort of comes to this next point, that most voting and registration crimes do require specific knowledge of ineligibility. A shout out to Mitchell and SCSJ for making this true in North Carolina, which again used to have a strict liability statute, absolutely ridiculous. But it's important to note that the mens rea requirement here is not just applicable to the act of registering, but to the fact that the registrants were ineligible. And this can make it a little bit different than many of the crimes that defenders often deal with. Because the fact is that many of your clients will not understand the complicated eligibility rules in their states. They often don't receive sufficient instruction or information from the state. And so casting a reasonable doubt around a mens rea is one of the strongest tools to defend against illegal voting or registration prosecutions. But many courts have struggled to apply these knowledge requirements correctly. So it's really incumbent on the defense attorney to make the court understand what the proper standard is. An example of that is another case that Mitchell talked about, Crystal Mason, who was prosecuted in Texas for casting a provisional ballot when she was ineligible. She had been sentenced to 5 years in prison, and she eventually won her appeal and received a new trial because the lower courts misapplied the mens rea requirement by failing to require a showing that she actually knew she was ineligible. So the Texas Election Code makes it an offense to vote in an election in which the person knows the person is not eligible to vote. And the Court of Criminal Appeals, which is the court of last resort for criminal cases in Texas, held that the language unambiguously imputes the mens rea requirement onto a subjective understanding of ineligibility, stating that a plain reading of the language requires knowledge that a defendant herself is ineligible to vote, not simple negligence. The statute does not allow a court to presume knowledge of ineligibility based solely on a provisional ballot affidavit. So at the trial court level, Mason had argued that she believed she was eligible to vote when she cast that provisional ballot. But the trial court judge did not take her specific intent into consideration, and the Intermediate Court of Appeals upheld that conviction. So the Intermediate Court of Appeals called her knowledge of her eligibility irrelevant and said that the state only needed to prove that she voted while knowing of the existence of the condition that made her ineligible, which in that case was that she was on federal supervised release for a felony. But again, the Criminal Court of Appeals disagreed and held that that was a misapplication of the mens rea requirement because they failed to require proof that she had actual knowledge that it was a crime for her to vote while on supervised release. This comes up so much in these cases. Prosecutors just assume that because somebody voted or registered, that they knew that they were ineligible, and will breeze by providing evidence of that in the affidavits and at trial. I think the important focus here is that we have all heard the axiom that ignorance of the law is no defense. But in these cases, ignorance or misunderstanding of the eligibility law is actually a mistake of fact, because we're talking about how that's applied to the person themselves. So it is a valid defense here, and it really should be focused on. I know we're getting low on time, so I'm going to breeze through a couple of these. I have an article in the December issue of NACDL's magazine that goes into more detail on these. And again, happy to talk about them more. But since there were a few questions in the chat about this, I want to make sure we get to it and have time to talk about it. Media attention can be a double-edged sword here. I think this has been pointed out. If you're shining the light on the injustice of these prosecutions, that can help create accountability. It can help the case. There's even been examples where it uncovers hidden evidence. But on the other hand, we know that the goal of these prosecutions is to suppress voting by people with felony convictions, to scare people away from the ballot box who are actually eligible. So more attention on them can amplify that chilling effect. It could also increase the wrath of prosecutors on your particular client and scuttle possible plea deals. So it's something to be really careful with. But I want to give an example of really strong reporting in one of these cases, and that's Sam Levine's reporting on Pamela Moses' case in Tennessee. There were a lot of charges that didn't stick against Miss Moses, but ultimately the one that did stick was for submitting a false election document. That was this document here. This is the Certificate of Restoration of Voting Rights, which is required in Tennessee to restore your voting rights after a felony. This form is entirely filled out by state and county officials. And the problem here was box 2, this section, which was filled out by Pamela Moses' parole officer, saying that she had been granted final release from incarceration or supervision, which her officer filled out and signed. But she was actually still on unsupervised supervision. And so based just on the fact that she submitted this and the prosecutor's unfounded assertion that she had tricked her probation officer into filling this out, Miss Moses was initially sentenced to 6 years and 1 day in prison for submitting false election documents. And while she was awaiting sort of finalizing the judgment, Sam Levine from The Guardian, who had been reporting on this case, uncovered this document that hadn't been disclosed by prosecutors, which is an internal email explaining that the officer who completed the form had been negligent. He wasn't tricked. He had just never been trained on how to fill these out correctly. Based on this document, Ms. Moses' sentence was vacated. Her charges were eventually dropped, and the media storm that ensued likely contributed to the prosecutor losing her election a few months later. So this is an example of fighting back against a prosecution and winning. And I think it's really both, it shows accountability even on the prosecutor who eventually lost her election because of this. But all of this was possible because of Pamela Moses' bravery and what she was willing to put on the line, right? We definitely couldn't begrudge her or anyone else in her position from taking a plea deal. But I think her bravery and seeing people like Pamela Moses fight back and win can really bolster other people to fight back. And the most important piece here is to have a really skilled lawyer who can help you win and help fight back and give people the sort of bravery to fight back against these cases and hopefully sort of squash the wave of them. So that's what I would say in response to Anne and Nicole is we need to amplify the cases where people do fight back and win. And we need skilled defenders to be out there helping people win these cases and create that accountability and sort of stop this wave. So I'll leave it there.
Thank you, Blair. I want to invite Mitchell back on to sort of weigh in on some of the things that you weighed in terms of the chilling effect and to sort of address Anne and Nicole's questions in the Q&A as it relates to that. And I'll just recite it for everyone's benefit. So Anne asks, particularly, is how can we acknowledge the reality and stop criminalization of voting, but not also contribute to the chilling effect of the very effective scare tactics of highly publicized arrests? And then really supplementary to that is Nicole's question about what might a communication strategy to counter the chilling effect of high profile prosecutions look like?
Yeah, so I'll start where Blair ended, and I think it's to Nicole's question. I think it's important to raise the profile of those high profile cases where we win. So the Pamela Moses work, I think that was a really effective way of pushing back, because if that's happening in Tennessee, that's happening in other states as well. And if I'm remembering correctly, in Florida, some of the prosecutions failed because it was brought by this. I'm misremembering the facts, but the crime was only in one county. It wasn't in multiple counties, and so that's why some of those prosecutions, failed. And so raising that profile of, hey, the state is not even following the law that is set for itself, because this is argument that I'm just trying to follow the law. Well, if you're really trying to follow the law, then you mean that you have to disclose, exculpatory evidence. Like you have to follow the law in Florida. The crime has to occur in 2 counties in order for the state prosecutor to do anything about it. And so, like that's one way, is raising the profile of that. And then to Ann's question, I think we can't be silent. Like we have to educate people about this issue happening, and letting people know what the law is, and what their rights are, and whether that is pushing the state to put out documents that are state sponsored documents that say, hey, this is how you restore your right to vote, or this is the current state of voting rights, and linking that to a web page from your organization. But we have to educate people about it, because if we say nothing about it, then they're just in the dark. So at least we have a fighting chance if we are telling them from a trusted voice in the community that, hey, here's what the law is, and here is our support for that.
Awesome. I want to thank our speakers, and a lot of the information and links that were shared. They are available on a resource page that we shared with registrants, and we'll reshare after today's webinar. Like we mentioned, it's going to be recorded, and so you'll get notified when the recording becomes available. And Blair highlighted, and Lisa Wayne, our executive director, highlight in the chat, but Blair does have a article that's the featured article for our December issue of the Champion magazine. The magazine is available to members, but we did share in the chat how you can become a member. And so definitely take a closer look at that. She outlines all of the great information in her PowerPoint, but really sort of sharing how to go about defending against the criminalization of voting. And stick with us. This is sort of a start of sort of a series of educational webinars on this. We're going to be tackling and diving into more state-specific issues. So looking at Tennessee, furthering and keeping up to date on Florida, looking at Texas as well, and really sort of doing deep dives in those states in terms of how to go about defending against voter prosecutions. Again, thank you for joining. You will get a survey at the end of in your inboxes, probably already have it, to just let us know what you think, and if you have any other ideas on future programming that we can host. But again, thank you for coming, and have a good afternoon.